Hello and welcome to LiveLaw Daily. I'm Debojit Das, and today is World Humanitarian Day. On August 19th of 2003, a bomb attack on the Canal Hotel in Baghdad killed 22 humanitarian workers, including Sergio Vieira de Mello, the UN Secretary General's Special Representative for Iraq then. 5 years later, the United Nations General Assembly designated August 19th as World Humanitarian Day to honor humanitarian workers and remember those who have lost their lives while helping others. And on that note, here are the key legal developments you need to know about today. For our first story today, the Supreme Court has given the Odisha Sentence Review Board one last opportunity to decide whether Dara Singh, also known as Rabindra Kumar Pal, should be released prematurely from prison. Dara Singh is serving a life sentence for the 1999 murder of Australian missionary Graham Staines and his two minor sons. He has now spent more than 26 years in prison. A bench of Justice Manan Mishra and Justice Vijay Bishnoi was told today that despite the court's earlier direction to take a decision by August 19th, the Sentence Review Board has still not decided his plea. The State's Council initially sought a passover, but the court questioned why there was still no decision. The Council then placed a letter from the Directorate General of Prisons on record, saying that information about Singh's antecedents was still being sought from Uttar Pradesh. Justice Mishra was clearly unhappy with the delay, saying, "We cannot tolerate this avoiding taking a decision." The court has now directed the review board to decide the matter by September 2nd and inform the Supreme Court. Otherwise, the court said it will take the decision itself. Dara Singh was originally sentenced to death in 2003. The Odisha High Court commuted the sentence to life imprisonment in 2005 and the Supreme Court confirmed it in 2011. Dara Singh is now seeking premature release, relying on the reformative theory of punishment and arguing that he has repented for his actions. The Supreme Court will take up the matter again on September 2nd. And for our second story, the Supreme Court is looking beyond just the latest NEET paper leak. This time, it wants to know what long-term institutional challenges are actually being made to prevent such incidents from happening again. A bench of Justice P.S. Narasimha and Justice Alok Aradhe was hearing pleas by the Federation of All India Medical Association and United Doctors Front, seeking reforms in the National Testing Agency after the NEET-UG 2026 paper leak. The court had earlier sought the centre's response on implementing the recommendations of the K. Radhakrishnan Committee, whose mandate was later expanded following the NEET-UG 2024 paper leak with inputs from the Nandan Nilekani Committee. Solicitor General Tushar Mehta explained the safeguards currently followed by the National Testing Agency. On the morning of the examination, sealed question paper boxes are opened under videography and in the presence of two students before the packets are distributed. He described the process as foolproof while acknowledging that human involvement can still lead to breaches. And that was precisely the court's concern. Justice Narasimha pointed out that these safeguards had already been examined by the Radhakrishnan Committee. The question now is whether those recommendations have actually been institutionalized. The court wants details about the National Testing Agency's institutional structure, its staff and officers, secure offices, cybersecurity infrastructure, testing and research capacity, and systems for training personnel across examinations. The bench also stressed the importance of institutional memory, that when experienced officers are transferred, their knowledge should not leave with them. Translation was another concern. Tushar Mehta said a question bank of around 500 questions is manually translated into 13 languages, while acknowledging that human involvement creates a possibility of a breach and that a breach had occurred with those involved arrested. The petitioners have also raised a larger concern. The proposed law must address situations where paper setters, vetters, or other authorized personnel misuse their access by copying, sharing, or transmitting examination material. The court's concern is therefore not simply about fixing 1 year's paper leak. It wants to know whether the reforms are strong enough to prevent students from facing the same problem again. For our third story today, the controversy over the Bar Council of India and Nalsar students has now drawn a strong response from the Bombay Bar Association. The association has condemned Bar Council of India Chairman Manan Kumar Mishra's August 13th letter concerning the 2026 graduating batch of Nalsar. It has also criticized the apology issued by Manan Kumar Mishra on August 15th, calling it belated and saying that it appeared to aim at calming the situation rather than expressing genuine remorse. In a letter dated August 18th, the Bombay Bar Association said that the apology could not be treated as an expression of true remorse because Mishra continues to remain the Bar Council of India chairman. The association went further, saying that in the fitness of things, he ought to have resigned. The Bombay Bar Association's standing committee met on August 17th and 18th to consider developments between August 13th and 15th. It described the original BCI action as an abuse of the office of the chairman, particularly because, according to the association, the students were not given an opportunity to be heard before the letter was issued. The association has also said that the August 13 action had given grave prejudice to the professional careers of the Nalsar students. So the controversy is now no longer just about the action against the students. The Bombay Bar Association is questioning the manner in which the Bar Council of India chairman exercised his office and whether he should continue in that position at all. For our fourth story today, the Supreme Court is continuing to hear the long-running dispute over who represents the real Shiv Sena, the Uddhav Thackeray faction or the faction led by Eknath Shinde. A constitution bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana today continued hearing the challenge to the Maharashtra Speaker's decision on the disqualification of Shinde faction MLAs, along with a challenge to the Election Commission's decision recognizing the Shinde faction as the official Shiv Sena. Senior advocate Kapil Sibal, appearing for Uddhav Thackeray, focused on the 10th schedule and argued that the legislative party cannot simply be treated as the political party. Kapil Sibal said that the Shinde faction had relied on the existing party leadership and structure to get elected, but later disputed the same leadership and claimed that its majority in the legislature made it the political party. Referring to the Constitution Bench's earlier judgment in Subhash Desai, Sibal argued that allowing legislators to first defect and use their numerical majority to claim control of the party would defeat the purpose of the anti-defection law. He also challenged the Speaker's reliance on the 1999 Shiv Sena constitution, arguing that the relevant party constitution was the 2018 constitution, which had been submitted to the Election Commission before the rival factions emerged. Kapil Sibal said that the Speaker had effectively treated the legislative party as the political party and had therefore exceeded his jurisdiction under the 10th schedule. He also urged the court to hold that the Shiv Sena name belongs to the Thackeray faction and that the Shinde faction should not retain the party symbol. After Kapil Sibal concluded, senior advocate Devdutt Kamath addressed the disqualification issue. He argued that if the Speaker's decision is found to be perverse, the Supreme Court can correct it in judicial review. But Justice Bagchi raised an important question. If the court can set aside the Speaker's decision, can it itself declare Eknath Shinde disqualified, or would the matter have to go back to the Speaker? The court also identified the central question. When Shinde gained the legislative majority, did he continue to represent the political party? That question now lies at the heart of the ongoing hearing. For our next story today, the Supreme Court is considering whether a woman officer in the Indian Coast Guard who has served for 14 years should be granted permanent commission. The bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi and Justice V. Mohana was hearing the plea filed by an assistant commandant who was denied permanent commission. Her counsel pointed out that she has around 4,500 hours of flying experience, more than that of several male and female officers, and said that the Coast Guard had earlier taken the position that there was no policy allowing women officers to receive permanent commission. Attorney General R. Venkatramani told the court that the Coast Guard has now acquired modern ships and that greater induction of women officers may be possible. He said that the authorities would explore whether she could still be accommodated, even though she would otherwise have left service in 2024. But the Chief Justice of India questioned the Coast Guard's position. Can you deny permanent commission because you do not have a policy, he asked. The Attorney General pointed to infrastructure limitations, saying that the Coast Guard operates in different conditions from the Navy and that facilities required for women officers have developed only gradually. The Chief Justice of India, however, said that if the Coast Guard has a system for permanent commission for male officers, it cannot simply deny the same opportunity to women because of its own lack of infrastructure. Justice Bagchi also noted that the officer had been recommended by her superiors. The Chief Justice of India ultimately said that the judgment was being reserved, but added that if the Coast Guard itself absorbs her, that would resolve the matter. And he made the court's position clear. We cannot allow an officer to be humiliated like this. The court noted that she was the senior most among the eligible officers and urged the authorities to show sportsmanship. And for our next story today, the Delhi High Court is examining a question that could affect how lawyers, researchers, and even judges search for judgments online. Can legal databases be prevented from allowing people to find court judgments simply by searching for a person's name? The issue came up in an appeal filed by IndianKanoon against a single judge's ruling recognizing a right to be forgotten and directing search engines and legal databases to de-index and disable name-based searches for certain judgments, particularly those involving people who had been acquitted or discharged. Senior advocate Arvind Datar, appearing for IndianKanoon, argued that a court judgment is a public court record and asked how far a court can go in directing legal databases to de-index or redact such records. He also argued that IndianKanoon should not be treated like a general search engine or a news website. The bench, led by Justice Hari Shankar, then raised a practical concern, which was that if a person somehow does not know the case number or other details, how are they supposed to find a judgment? Justice Shankar observed, and I quote, "No one knows what is the writ number of case details," and said that if public interest is a consideration, there is certainly a public interest in being able to access judgments. The court also noted that legal databases such as Manupatra and SCC Online are used regularly and that restricting searches to case numbers or other details would be a Herculean effort and not even remotely a substitute for word-based searches. On the other side, senior advocate Akhil Sibbal argued that other intermediaries had complied with the single judge's order and that the distinction between masking and de-indexing had already been considered. The court has now issued notice in the appeals and listed the matter for September 2nd, observing that the case raises serious questions about accessibility of judicial records. At the heart of the dispute is a larger question, and that is, how do you balance a person's right to privacy and to be forgotten with the principle of open justice and public access to court records? For our seventh story today, the Delhi High Court has reserved its verdict on a public interest litigation seeking safeguards for homeless people and those displaced by demolition drives during the ongoing Special Intensive Revision or SIR of electoral rolls in Delhi. A division bench of Chief Justice D.K. Upadhyay and Justice Tejas Karya was hearing the plea, which argued that people who have been rendered homeless or displaced may no longer be available at the addresses recorded in electoral rolls, making it difficult for them to participate in the house-to-house enumeration process. The petitioner claims that more than 3 lakh people affected by demolition drives could face this problem. Senior advocate Satyakam told the court that a representation had been made to the authorities on July 10th, but the concerns had not been addressed on the ground. He sought measures such as field verification by booth-level officers, relaxation of procedural requirements, and special enrollment camps. The Election Commission, however, submitted that appropriate measures had already been taken. It referred to Form 6, under which a homeless person can establish residence at a shelter home. The bench questioned the petitioner on the absence of specific details about people who had actually been left out of the SIR exercise. The court also made it clear that it was reluctant to turn the public interest litigation into an exercise in monitoring policy implementation. Everything should not be thrust upon courts. It is not that we don't share concerns, the bench observed. It said that the authorities have constitutional functions to perform and that if there are problems with implementation, the court cannot simply be expected to monitor the entire exercise. The petitioner ultimately asked the court to direct the authorities to decide his representation and leave him free to take further legal steps. The bench has now reserved its verdict. For our 8th story today, a professor who claims to have expert knowledge on Vinayak Savarkar has moved the Bombay High Court after a Pune court rejected his plea to intervene in the criminal defamation case against Rahul Gandhi. Pankaj Phadnis had sought to intervene in the case filed at the instance of Savarkar's grandnephew, Satyaki Savarkar. But Special Judge Amol Shinde rejected his plea and imposed a 20,000 rupees cost, holding that he had wasted the court's time. Phadnis has now challenged that order before the High Court. He says that the special court is going beyond its jurisdiction and is effectively trying to determine whether Savarkar was brave or coward. He has also sought a stay on the proceedings against Rahul Gandhi and asked for an amicus to examine whether evidence being considered by the special court is actually relevant to the original complaint. Phadnis claims his research had led to conclude that Savarkar was a person worthy of respect. He also argues that Rahul Gandhi's repeated criticism of Savarkar violates his own Article 21 right to a meaningful life. The application is likely to come up before a division bench of the Bombay High Court. For our final story today, around 1,157 advocates in Kerala could soon find their names published on the websites of the Kerala High Court and the State Bar Council. But why is that? The Kerala High Court is hearing a public interest litigation concerning advocates who are allegedly practicing without a valid certificate of practice or without clearing the All India Bar examination. A division bench of Chief Justice Somen Sen and Justice Shyam Kumar VM passed an interim order on a plea filed by Amarnath Joshi, alleging that the Bar Council of Kerala had not properly enforced the rules governing the right to practice. The Bar Council placed before the court a list of advocates enrolled between July 2010 and December of 2021 who had not cleared the All India Bar examination. The court has asked its ad hoc committee to verify whether these advocates have applied for a certificate of practice. In the meantime, the court directed that the names of all 1,157 advocates be published on the High Court and Bar Council websites. More importantly, if any of these advocates files a wakalatnama, the matter should not be registered, and the fact of such filing must be recorded in the case file. The ad hoc committee has also been directed to publish the list of defaulting advocates and take further action under the 2015 verification rules. And that's all for today's LiveLaw Daily episode. From important hearings in the Supreme Court and High Courts to developments that could have a wider impact on the legal system, we'll keep bringing you the stories that matter. I'm Debojit Das. Thank you for listening and keep following LiveLaw for the latest updates from India's courts.